A new player in the field of baking release agents poached 2 employees from a leading competitor, which sued for trade secret misappropriation, among other claims. The sweeping preliminary injunction that followed was challenged on appeal in the 2021 case, Mallet and Company versus Lacayo. Mallet and Company was an 80-year veteran and leader in the baking release agent field. Baking release agents are lubricants that make it easier to remove baked goods from their containers. In 2017, Bundy Baking Solutions decided that it wanted to enter the baking release agent field and formed a subsidiary called Synova for that purpose. In 2018 and 2019, Synova hired 2 longtime Mallet employees, Ada Lacayo and William Bowers, to serve as its lab director and business development manager, respectively. Before leaving Mallet, Lacayo copied over 1,000 files to a USB drive and emailed formulas and other information to her personal email account. Bowers also emailed Mallet's customer and product information to his wife's email account before wiping all of his Mallet electronic devices. With Lacayo and Bowers' help, Synova was able to quickly make and sell baking release agents to Mallet's customers. Mallet sued Bundy, Synova, Lacayo, and Bowers in federal district court, raising trade secret misappropriation and other claims and seeking injunctive relief. The district court found that at least some of the information that Lacayo and Bowers shared with Synova qualified as trade secrets. However, the district court didn't explain exactly what information qualified as trade secrets. The district court also found that there had been a misappropriation of Mallet's trade secrets that threatened irreparable harm and entered a preliminary injunction. The injunction broadly prohibited Bundy and the other defendants from using any of Mallet's trade secret information. It also prohibited them from making or selling any products that competed with Mallet's products. The district court set a $500,000 bond to secure the injunction, reasoning that this was on the high end of bonds for similar cases and that the amount the defendants were asking for was just too high in comparison. Bundy and the other defendants appealed to the Third Circuit.